Well, this must be a good idea. Thank you all for coming. Up here with me tonight are Bill Andersen, who most of you know, and our special guest, Hugh Spitzer. The credit for this evening goes to Bill, of course, because, as you know, he does his annual review of Supreme Court decisions, usually sometime in July or August, and following that, he got interested in putting on a program where we might talk a little bit more and learn a little bit more about the United States Supreme Court. And so that's what the evening is about. And Bill, I think most of you know, but if you're new here and you don't, is a former retired law professor from the UW, where he served for many years teaching constitutional law. His education was at the University of Denver, where he got both his bachelor's degree and his bachelor's in law. Later, he got his master's in law from Yale Law School. He is very widely published in books and articles over the years. Some of you may not know, if you're new here like me, that he served as president of the Residence Council for 2 years during his term in 2013 to 2015. Our special guest tonight is Hugh Spitzer, who is a professor of law at the University of Washington School of Law. He took his bachelor's degree with honors from Yale University, his JD from the University of Washington Law School, and his master's in law from the University of California. Hugh's areas of experience include comparative law, constitutional law, legal ethics and professional responsibility, local government and municipal law, Washington state constitutional law, and get this, Roman law. He also is widely published. When you look at the list, it's too long. If I tried to repeat it, we wouldn't have a program tonight, so I won't do that. But he teaches courses in constitutional law, constitutional structures of government, local government law, Washington constitutional law, problems in professional responsibility, which he told me is a long way of saying legal ethics, and Roman law. So with that, I'll turn it over to Bill.
Thank you, Sam. Is this going to be loud enough if I stay close to the microphone? I'll try and do that.
Turn it up.
And if I
Tilt it up. Tilt it up a
can
little.
it be turned up? I don't know. Tilt it up.
There.
There?
Okay.
Ice cream cone.
Well, I may just hold it in my hand if it doesn't work better that way. Thank you, Sam, for that introduction. And it's always a pleasure to come and talk to my neighbors here about these questions. And we have a very special guest in you who's going to talk about the proposals for reforming the Supreme Court. The Supreme Court is in a situation where there's a lot of interest in reforming it, and that tells you something, I think, about the popularity of the court's output. So it is very timely. There have been some major studies in the last, very recently, of the kinds of reforms that are possible, and I think he was going to tell us about that. My job is a little simpler one. I'm just here to introduce Hugh, basically, but I did want to say a couple of things about the nature of the beast itself. The court. What is a court? What do we mean by a court? Most of us understand what a legislature is. And folks sit around a table and they decide policies. They decide what's good and what's bad, what should happen and what should not happen, and they write it down and get it enacted in law. And that's what legislators do. They're policymakers. And we pretty much know what executives do, mostly. We've had some unusual examples in the last few years of executive behavior nobody could have anticipated. But let's put that aside. You kind of know what the executive function is, whether it's at the local level where the mayor is the executive, or the state level where the governor is the executive, or the federal level where the president is executive. And the executive and his or her associates administer the laws that the legislature passes. They carry them into execution. They prosecute people who violate them, and they make studies and so on. Manage the store, so to speak. Everybody understands what that's about, but nobody's quite sure what courts do. And we got all three of these branches in our government. Three branches, incidentally, invented by Aristotle, I think, at least in our traditions. We think it just goes back to the Enlightenment. No. Aristotle thought of it long before we did. James Madison was very bright, but he wasn't original. So I think it's when you ask yourself, well, I know what the executive does, I know what the legislature does. I'm not quite sure I know how to describe what it is the courts do. Let me give you a simple, clean, nonpartisan, boring, interesting example. Suppose the city council passes an ordinance, no vehicles in the park. Okay, that's the legislative act. They discuss the pros, they discuss the cons, they talk to people about vehicles and injuries of vehicles and what vehicles do to the air pollution and the noise levels and the danger and other kinds of things. On the other hand, the values of vehicles in terms of access to the park. And so there are lots of...
Can't quite hear you.
Can't quite hear? I'll just use my rock star. What should we sing?
Yeah.
Anyway, so the legislature has passed this law, and the executive hires some people to go out and enforce it. And the particular law says no vehicles in the park. And you can imagine the legislative debates that went on about that. Yes, we want it. No, we don't want it. It's a good idea to have vehicles. Not a good idea. All those pros and cons of the policy were decided by the legislature. And the executive doesn't, usually anyway, the executive doesn't question that. It just goes out and enforces the laws that are passed. Well, if somebody rides a bicycle into the park and the park agent gives them a ticket on the theory that it's a vehicle and no vehicles in the park, and the cyclist says, well, wait a minute, they didn't mean bicycles when they said vehicles. They were talking about motorcycles, trucks, and SUVs, and big, noisy, dangerous instruments. Bicycle is quiet, it's safe, it's simple, it's good for the environment. Certainly they didn't mean to prohibit those when they used the word vehicles. Well, if the cyclist and the prosecutors can't come to some agreement, which usually they do, it winds up in the court. And the court's job, and this is the core of the central function of the judicial function, court's job is to resolve a dispute about the meaning or agency of the meaning of the law or some executive action when the dispute involves a specific individual. So the legislature passes a law that says no vehicles in the park. That applies to everybody. When the court gets down to it, they're talking about, is Joe Smith going to go to jail for this or not? They're talking about a specific individual. When it reaches that stage in the enforcement process, where you have a dispute about the meaning of the law, in a case involving specific parties, then somebody has to make that decision, and that's the job we give to courts. And it's quite different from the legislative function, which is to choose policies, good or bad. Quite different from the executive function, which is to enforce the law that's laid down. It's a different kind of thing. And if you ask yourself, well, what kind of people ought to do that sort of work, and what kind of work is that, you get a lot of different kind of answers, but it is a different function from the legislative and executive functions, and you need to think a little bit about that. Now, in this particular case, what do you think the judge should do? Looks at the bicycle, and yes, the guy was on the bicycle. There's no facts in dispute. It's not a factual matter. And then the question is, well, should I interpret the word vehicle to mean bicycles or not bicycles? How does the judge do that? The answer you get if you're in law school or reading about this stuff is, well, you look to see the intent of the legislature. That's the usual formula this is used. What did the legislature intend? What did they mean when they used the word vehicles? Did they mean bicycles? If so, this guy's guilty. If they didn't mean bicycles, this guy's not guilty. So that's what the court does. And most of what judges do in disputed cases is try and figure out what the intent of the lawmaker was. How do you do that? Who do you look to? Well, one thing you've got is the words the lawmaker used. You start there. And you try and decide, what does that word mean? And you might say, well, let's look it up in a dictionary. Look up vehicle in a dictionary. You'll find some phrase or sentence that says something like it's a device or gadget used to transport people or goods from here to there. That's a vehicle. Well, that would certainly cover in normal terms a bicycle, wouldn't it? But on the other hand, you're not quite sure that that's what they had in mind. So how else do you find out what the intent of the legislature was? Well, at this point, the case would go on into examination of the legislative record, what testimony was held, what reports were made by legislative committees, what statements were made by the proponents of the bill, and what statements were made by the opponents of the bill. And at some point, the court's going to get a sense, a feel, as to what the court thought the legislature really intended this to mean, and it will apply that. Now, this is a very chancy process, and lawyers have been arguing about it for literally centuries, and there's no simple formula as to how to go about it. But let me show you what the granddaddy of them all, our most famous Chief Justice, John Marshall, said about this in 1827. This debate's been going on a long time. It's not strike you as new. Here's what Marshall said. It has been said many times, and no more is necessary. It is the intention of the instrument, that is the law, which must prevail. That this intention must be collected from its words, that the words are to be understood in that sense in which they are generally used by those for whom the instrument was intended, that its provisions are neither to be restricted into insignificance nor extended to objects not contemplated. Now, that's very clear. But that's iconic language, and what it tells you is that we don't really know very much about figuring out what the legislative intent was, but somehow judges and better judges and experienced judges do this pretty well. And they say, well, we think the words mean this. Now, there's a tendency for us folks outside this business who don't see it a lot to say, well, words have a sort of natural meaning, and we should take them in their natural sense. Well, okay, words do have a natural meaning, and mostly that's the way it's used. But if you've had experience with the legislative process, and I know a number of people in this room have, you'll know the kind of debates that go on in that process about words. Some says, well, I think we should prohibit bicycles. No, I don't think we should prohibit bicycles. Well, I got to get both of their votes to get this one passed. How would you guys settle for no vehicles? And then we can debate later whether or not that includes bicycles. Oh, okay. That is, there may be some ambiguity built into the law intentionally to get the coalition together. You need to pass it. So ambiguity is a word of art, not just a careless observation. So think about that. The best statement I've seen about what judges do in a case like this, and let me just read it to you because I think this is something that is worth reflection. The underlying professional task of the judge is that the judge should seek to extract from the prior judicial and legislative history of the issue. Okay, you're going to extract something from that prior history. Some principle which can be intelligently applied to this dispute and which can be persuasively explained. Now, if you think about that, it's looking backwards. We're not talking about the future at this point. What is the history of this? Well, how has this phrase been used before? And if in the various ways it's been used, in the various circumstances in which it's been interpreted, is there some principle that emerges that we can use in an intelligent way to resolve the dispute in front of us and be able to explain that rationally and persuasively? That's a good statement, I think, of what the best judge does. Now, with that premise, and I don't want to take too much time here, but I just want you to get that sense in mind, because that's not the way you think of, most people think of the Supreme Court today. Because in that model, that simple model, the personal preferences of the judge, do I like bicycles and don't like bicycles, wholly irrelevant. And any cries from the community for this or that, we hate bicycle gangs that are terrorizing the parks. Judge pays no attention to public opinion, pays no attention to his own personal beliefs, tries to figure out what the intent of the legislature was through a process like the one I've just described. Now, that's not what most of us feel about the Supreme Court today, and that's the reason why we have this conversation tonight, because there is something else going on. We've got in the process of nominating and confirming members of the court, in the process of having presidential elections, where there doesn't seem to be anybody interested in let's find the best judge, the one who can do the kind of things we've been talking about. Let's find a judge who will decide the cases the way we want to decide it. And you even have a presidential candidate back in 2016 who promised. He said, if I'm elected, I will appoint judges who will overrule Roe against Wade. I mean, he made a promise. They got a biased judge. And what happened? Well, we elected him. Now, I say we. Maybe not everybody in this room voted for him. I'm not even going to ask for a show of hands. I didn't want to embarrass either of them. It seems to me when the president, you can find in George Washington's papers a speech he wrote about the most important thing I have to do. Washington had some important things to do. The most important thing I have to do as president is pick really good judges, because it is a very critical part of the governmental process to have people who can take the job in the professional sense we've been talking about and not turn it into a political game. But today we've moved a long way from there, and we have, as I say, presidents who are making campaign promises about the kind of biased judges they're going to appoint. And that particular president, as you may recall, kept his promise. Maybe the only one he ever kept, I don't know, but he did keep that one, because he then went out and instead of just looking for judges who he liked, he went to an interest group and he said, give me a list of names and I'll pick my next nominee from that list. So the president has sort of defaulted on his presidential responsibility and asked the interest group to come up with the candidates. And that's exactly what happened, and that's exactly, and we've had some bad pieces of luck if you don't like that outcome, and when people died and some other legislative chicanery that went on to keep the matter from being otherwise. But you look at the situation and it's very clear that this president has sort of, if that's the way it's going from here on out, we don't have a court that behaves in the professional way we describe. We have a court which is a partisan organ of government, and which it's not supposed to be. So that's, I think, kind of where we are today. And if you've been listening to any of my reviews of the court's work in the last couple of years, you'd see it's been going on for 10 or 15 years. The court has been more and more conservative. It's not just Trump's appointees. It's a lot of other appointees and a lot of other people. So we've had the Second Amendment case, we've had the voting rights case, we've had Citizens Union, we've had various kinds of things that keep creeping in a conservative way. And now I think with the latest appointments, we got a very conservative court. So that, and I think dedicated to particular values, not judicially executed responsibility. So I think that that's something we all have to regret. And I think that it's because of that difficulty, because of that shift in the character of the court in a lot of people's minds, I think we have to think about the possibilities of reform. And that's one of the reasons we're here tonight. Is there something we can do to reform the system so that we can get back to a more professional kind of court and a less political kind of court? And I think that's something that's very much worth talking about. And just a final word about the history of this. As you will know, if you've had his American History 101, when the founders sat down after the Constitution was ratified, even before it was ratified, they were debating what the role of the court's going to be. So we have Federalist Papers before the ratification, in which Hamilton talked about what courts can do, what they can't do. We thought it was a terribly important thing to have good judges, because there will be times when battles have to be fought between the other branches, and you've got to have the right kind of people to do that. After the very first act Congress passed when it came into being after the Constitution was ratified, was the Judiciary Act of 1789, set up the court, set up a system of lower courts. And the Constitution doesn't say much about the Supreme Court. There will be one. The members of the court will have life tenure. And that's about all. There was no lower court system provided for them, so Congress had to come in and do that. They set up court. If you look up the list of the Judiciary Acts in that time, you'd find they passed one, and then in 2 years they repealed it and passed another one with a different provision. The structure of the court has been critical in our early history, all the way up to today. And it's something that is a very important kind of historical process that you might know something about. And if you think about up through the Jeffersonian election, 1800 was pretty early, but we didn't have a clear winner. Jefferson going to be president or Adams, and you wind up with the Adams people who were going to get voted out soon, passing the second Judiciary Act, which cut the numbers on the court from 6, where they started, to 5, on the theory that if Jefferson wins, he's not going to get to appoint that 6th justice, because there ain't going to be no 6th justice. So they cut it down to 5. Then Jefferson wins in the congressional vote after 36 ballots. I do think we got political difficulties today. 36 ballots, Jefferson's named president. The first thing they do is repeal the act that Adams people just did, move the number back up to 6, so Jefferson could appoint somebody. That sort of stuff that's been going on from that time on. And you can track it all the way down through Franklin Roosevelt in the 30s, which he was going to talk about, and various other places along the way, where the size of the court, which is as low as 5 and as high as 10, I think, it moved around a lot because it's a topic that has been very much concerned how the system is going to be operated. Now, the only thing I want to say before I turn it over to Hugh is that if you have the view that the court should follow public opinion, could we see, that's the first slide. Here's just a schematic. There's no numbers or dates on here. Think about, on the vertical axis, any issue you like, abortion, aid to criminals, whatever. And there will be some people who are in favor of it, some who are not in favor of it. And the next slide will show that public opinion on this sort of thing varies. Some years it's up, some years it's down, it goes up and down all the time. Does the court follow that public opinion? And the answer is that it does, sort of. There's a certain lag. But after a while, the court kind of catches up with public opinion on a lot of these things. And that's, I think, an important thing to remember. The court doesn't ask about, or shouldn't ask about, what the public opinion requires in this case. That over time, it changes, the court changes. And it doesn't change because judges change their minds, although now and then one will. It changes because we get different judges. And that happens when somebody dies or retires, there's a new appointment, and the case shifts. So it's not that the court is, the new court has now decided suddenly we're going to follow public opinion. It's just that we have new courts, new judges who see different things, have different experiences, have more information about the problem, et cetera, and believe the public has got the right idea and begin to move in that direction. The difficulty, and the one that brings us here tonight, is, well, here's some just examples. That's one in which we talk about the New Deal legislation, where I think the court was well behind where the public was on that stuff. And the next example is school integration. I think the court, you can argue about this, but I think Warren's court was a little ahead of the population at that point. And the final one on gay rights is one in which the court was very negative about it, but the increasing popularity of those rights with respect to the public has been sort of pulling the court in that direction. So, but the thing that brings us here, listen to the next slide. The curve showing the court's opinion isn't a smooth curve like the public opinion. It goes along at one level until there's a retirement or something that happens, somebody dies, and then they have to appoint somebody else to court, and that may change it radically. So what we have is a stair step, and that means a lot more space between the two lines. And if that line is very long, that red line, in time, or very far from the public opinion on the vertical axis, then it seems to be you've got some dysfunction that needs to be addressed. And so one of the things I think we're going to be talking about is what you might do to that process to see if we can get the red line to move in smoother increments and track a little more closely what the public really wants. Okay, that's all I have to say, just to suggest to you that Hugh is not going to talk about the steps that have been taken, the studies that have been made, the pros and the cons of some of these things. And they're very difficult issues to resolve. And I think it's nice to have an expert with his wisdom to help us sort it all out. Hugh.
Great. Nice to see everybody here this evening. If you can't hear me, just raise a holler and I'll try to raise my voice. I will say that Bill's great example about the vehicle of the park is something the ancient Romans thought about. Because if you look at the law of Caesar on municipalities, which was actually a charter for the city of Rome, enacted in 44 BC, maybe that's what knocked him off, it has this really interesting provision that says no vehicles on the streets, no wheeled vehicles on the streets between 6 o'clock in the morning and 4 o'clock in the afternoon. But they're not going to leave this one to the judges. It then says, this provision shall not apply to carts carrying the Vestal Virgins to ceremonies, or to priests who are, going to ceremonies for the immortal gods, or heroes of the people who are having, great processions after a victory, or for certain firefighting vehicles. Anyway, they were thinking this one through. Okay, now that's a different talk. I'll come up to 1937. And many of you are familiar with the court packing plan that FDR proposed, because the U.S. Supreme Court, mostly by 5-4 votes, had knocked down a whole lot of parts of the New Deal program, Agricultural Adjustment Act, the National Industrial Recovery Act, and so after he won big in 1936, he proposed this notion to counteract the court's frequent invalidation of his programs by allowing the president to add one additional member to the court. There were 9 at the time, as there are today. One additional member for each current justice who reaches the age of 70, and which used to be an old age. And to reach 70 and didn't retire, you'd add an extra one. Well, that would have put 3 or 4 right on the court and would have given him the opportunity to have people on the court that were closer to his concerns. The proposal was that the court could expand, but not to more than 15 justices. Well, as you know, it didn't pass, partly because the main senator who was pushing it died, as the chair of the relevant committee. And then there really was a public reaction, because they really wanted to have the court be impartial and not necessarily just reflect what the president wanted, much as they liked FDR. Now, today's problem, and these are issues that have come up over the past few years, there's basically been, for the last 3 or 4 years, almost a national political crisis every time a seat opens up on the Supreme Court. Lifetime appointments skew the membership of the court. And one of the peculiarities is that when the lifetime appointment to the court was written back in 1787, people didn't live as long as they do today. And so, and people would serve on the court about 14 years, and now it's about 23, 24 years. Makes a huge difference. The other thing is, and Bill alluded to this, is that Mitch McConnell basically blew up the norms in the Senate. You may be for or against the filibuster, but when it came to judicial appointments, one thing the filibuster did is it forced presidents to appoint moderate members. Nixon and Reagan appointed lots of middle-of-the-road former Republicans to the court whom we today view as being by and large liberal compared to some of the people on the court today, because they were basically middle of the road and they followed the rules. Mitch McConnell blew it up by getting rid of the filibuster for court appointments so that he could jam through the kind of people that he wanted. Also, bear in mind that there is an intrinsic conservatism with 2 senators per state, because the rural states that tend to be more conservative have 2 senators, and we have 2 senators, and California and New York have 2 senators. So we've wound up with an ideologically unbalanced court, partly because of serendipity of when deaths and retirements occurred. For the last 44 years, the Republicans held the presidency for 24 years and appointed 11 justices. In the last 44 years, Democrats held the presidency for 20 years, but only 4 justices. So there's been a disconnect. And when Joe Biden ran for president, somebody asked him at some press conference, what are you going to do about the Supreme Court? Do you think we should expand the size of the Supreme Court? And he kind of mumbled around, and then the next day after talking to people came back and said, well, I'm going to appoint a commission. He did not want to get into that one. I don't blame him. And so he appointed the Presidential Commission on the Supreme Court of the United States. And it got rolling very early in 2021. Even before he was elected, people were kind of working his staff to see if they could get appointments. And it turned out to be a very balanced group. It included lawyers and law professors from across the political spectrum and philosophical spectrum, from progressive to moderate to conservative academics, sort of Federalist Society types. That's the special interest group who's been making these appointments recently. And the commission was top-heavy with East Coast Ivy League types, but apart from that, it was pretty balanced. And the report that they came up with is exceptionally well written, and I really commend it to you. You learn a whole lot, and they really thought through these issues.
How long is it, Hugh? How long?
The report is about 288 pages, but that includes all the appendices. But it's really well written. The staff did a fabulous job, and they covered the topics of term. Should you have an extra? Should we expand the size of the court? Should there be term limits? And then there's one other batch of little topics they came up with, partly from a push from the more conservative members, and I'll talk about that at the end. The commission came up with a number of options. They did not make specific recommendations, although there really, I believe, emerged a consensus view, but they weren't supposed to say this is the one thing we're for, but I'll tell you what that is in a minute. But they reviewed how Supreme Courts and constitutional courts specifically, because some countries, Germany, France, Austria, Japan, Korea, Indonesia, a lot of countries, split the constitutional court from the Supreme Court. Germany actually has several Supreme Courts. You have a Supreme Administrative Court, a Supreme Social Security and Benefits Court, a Supreme Administrative Law Court, a Supreme Labor Law Court, and then just a general civil law Supreme Court, a criminal law Supreme Court, and a constitutional court. That's a lot, but it's Germany, they can handle the complications. So anyway, the Commission's report talks about how it's done in the rest of the world. They talk about pros and cons of expanding the court. court, pros and cons of term limits, and they zero in on an 18-year term. I'll talk about that. And then they talk about whether it's possible to rejigger the court through only a constitutional amendment, whether it can be done just by statute passed by Congress, and then they talk about some of these other issues. Constraining the court's ability to overturn legislation. That's the one that's been a favorite of conservative academics since the 1960s. A lot of conservative legal scholars argued that unelected federal judges should not be able to overturn the decisions of popularly elected legislatures. This has not always been a conservative thing. James Bradley Thayer, who was a progressive professor at Harvard in the late 19th century, really pushed for this because of the conservative court at the time. Oliver Wendell Holmes Jr. was very skeptical about courts overturning legislation, and he was, I would say, very moderate. He was not progressive, he was not conservative. He didn't care. He just tried to call it the way he saw it. And anyway, intellectually honest conservatives, even though the court has changed now, they continue to wonder about whether the court should be able to overturn legislation like gun legislation or gun control legislation or legislation controlling big money in politics. The not so intellectually honest ones have switched their views. Okay, let's look at a few other courts quickly. The granddaddy of the modern constitutional court comes from Austria. It was set up in 1920 when Austria became a republic. They only hear constitutional questions. They have 14 members. 8 of them are appointed by the cabinet, that is, whoever's in the government currently, and that changes from time to time. 3 by the, what we would call the House, and 3 by the Senate. And then the cabinet appointments, though, have to be career judges, civil servants, or law professors. I love that provision. And then they split up into small panels to hear the cases. They only rarely all come together. Next door in Germany, they've got 16 members split into 2 senates, so 8-member panels that hear cases. 6 of them are professional judges. The others are academics, civil servants, or lawyers. That requires a 2/3 vote of Parliament, both houses, both what we would call the House and the Senate, mandatory retirement at age 75, and certain constitutional decisions require a 2/3 vote, and others unanimity. UK, United Kingdom, 12 members. This is a pretty new statute that set this up. They're nominated by an independent commission comprised of representatives from Scotland, Northern Ireland, and then England and Wales. The Chancellor, the Prime Minister, and technically the King are expected to appoint the single name that comes from the commission. So it's very professional, and they get professional judges. Korea, 9 members, 3 by the President, 3 by Parliament, and 3 appointed by the Chief Justice of the Supreme Court, that is their other Supreme Court, on the legal side, and this is the Constitutional Court. Again, they got to be professionals. Last one, Indonesia. They've got 9 members. They've got to be 55 years old. They can serve up to 3 5-year terms, and then they have to retire at 70. There are 3 appointed by each branch of government, and it's rotating, and they're very hard to get rid of. Although I wrote an article with an Indonesian professor last year, a couple of years ago, that shows how they knocked off the Chief Justice because he was being too tough on the government on K-12 school funding. So, really interesting. Okay, so let's take a look, dive a little deeper into the Presidential Commission's report. The first thing that, after the sort of the history and the review of what goes on around the world, they talk about, well, what about the possibility of adding some seats to the court? That's something that a lot of people on the progressive wing of the Democratic Party have been pushing. This is a cartoon of Roosevelt basically saying to an umpire, that's Charles Evans Hughes, who's the umpire, he's the Chief Justice. He says, you know, I don't like your decisions. I think we got to change, you're calling too many strikes. And I think we need to change the members of the court. And that didn't work. Okay, so the arguments as outlined in the Commission's report, the argument for expanding the court, it starts basically with the norm violations. That is, Mitch McConnell's violations of the rules, both going from 2/3 to a majority, and he held the majority in the Senate. And then he holds up the President Obama's appointment of Merrick Garland. He holds it up for nearly a year, and because he says, well, we ought to let the voters decide. But then when Ruth Bader Ginsburg dies, he runs through Amy Coney Barrett in a few weeks. He just smiled when people asked him about that. But a lot of people said, you know, they violated the unwritten practice, the constitutional norm that's not in the Constitution. This is one of the problems in our Constitution. We have a lot of norms that aren't written, and people like Donald Trump, who doesn't care about norms, can just throw them all out the window. Okay. Another argument is that we need to prevent the erosion of democracy. The court needs to be, as Bill pointed out, somewhat more responsive to shifts in public opinion. Remember, it's not just that the judges, because these are, you know, long-term or lifetime appointments, it's not that they very often change their minds because of public opinion, but judges' worldviews and their own opinions change just like the rest of the upper middle class educated population that they come from. And so as people in the society shift their views, judges do shift, and this is another effect. But having a court that would be somewhat more responsive to electoral shifts in a gradual way, and to right now, though, expand the court so that it really reflects the people. This is an argument. And they are also, the people who want more people in the court say it's somehow going to strengthen the court. Now, the arguments against court expansion is that it would be an attack on judicial independence, the same criticism as Roosevelt's proposal. It would undermine the court's legitimacy, and a democracy really needs to have an independent court that doesn't just have its size expanded and contracted every 10 minutes like it was in the first few years of the Republic. Yeah, there's some other sorts of things in terms of expanding the court that the report talks about, like in some other countries, rotating the members of the court, a much larger court, between panels or up and down with the lower courts, or basically as new people come on the court, you take the ones who've been there long enough and you increase the size, and then you rotate them into kinds of jurisdictions that nobody cares about. But they still get the same salary. There was even one proposal the Commission's report mentions, which says that judges should be appointed evenly by the two major political parties. This is a terrible idea, in my opinion. But anyway, frankly, I think that changing the size of the court is a non-starter at this time. And you can smell it in the Commission's report. They think so too. Now, how about term limits? The United States is an anomaly. It is almost the only country in the world with lifetime appointments to the judiciary. This is a picture of the court in about 1898. Yeah, and some of these guys, they always put the older guys in front. Okay, so the core proposal, the one that I think the people on the Commission had a solid majority, both liberals and conservatives, saying, yeah, this is a good idea if we can pull it off. The idea comes from Norm Ornstein. He's a conservative political scientist who works for the American Enterprise Institute, a business-oriented, moderately conservative think tank. And about 15 years ago, he said, look, this is really simple. You set up terms that are 18 years, and the members of the court then rotate off in such a fashion that each president in each term gets 2 appointments. So the court gradually reflects the shifts that are driven by the voters. Thoughtful idea. Another approach some people have suggested is 12-year terms. Each president gets 3 appointments, but that didn't per term. But that in a sense makes the court too reflective. I think people on the commission concluded just too reflective of voter shifts. So that's the proposal. The court stays at 9 members. Each president gets 2 appointments per term. Former justices get a choice. They can either go senior and they can work in a lower court, or they can simply retire. If they stay on senior status today, they get a full salary. If they retire, they essentially get a pension. We've got some senior judges who are really active. Here's 3 who've been in the news. Lewis Kaplan on the upper left, by the way, he's Henry Kaplan, the oncologist here in Swedish. It's his brother. And Lewis Kaplan is the judge in the Jean Carroll case in New York City. He's a senior retired, in quotes, judge, just like Hank Kaplan. He never really retires. Hank is doing less work now, I guess. And then Raymond Deary on upper right. He's from the Eastern District of New York. That's Brooklyn and Long Island, and he's senior status judge. But he's the special master in the Mar-a-Lago case, and causing the very junior 12-year-old judge in that case a lot of trouble. So, and then David Souter, who got sick and tired of the politicization of the Supreme Court and hated living in Washington, D.C., he just quit. He went back to New Hampshire, but he turns up all the time on First Circuit cases. He enjoys it. He's very active. Now, with this notion with 18-year terms for our judges, with each president getting in each term 2 appointments, there are a few devils in the details, and the commission's report goes very nicely into it. You know, should when you're putting in this new kind of system, you have transition issues. What are you going to do with the people on the court today who've been there for 18 years or more? Do they have to leave? Or do you have the court expand for a while until they finally retire or die? Or, you know, so do you temporarily expand the court as new justices join? Or do you start those new 18-year justices as the current justices retire? And what do you do with premature vacancies anyway, if someone's in the middle of her 18-year term and she retires or dies? How are you going to handle that? A lot of little devils in the details. They're not easy answers, but the report has some good ideas. The argument for term limits is, number one, why the heck should the United States be the only place on earth that doesn't have term limits and these people can be on the court forever? It just doesn't make sense. Also, that predictability would smooth things out and reduce jockeying, you know, like what McConnell did to Obama and so on. And then if you have an 18-year term plus post-service financial security, it sufficiently safeguards judicial independence. The people on the commission who didn't like this approach said that the life terms completely insulate the court from political pressure. there are arguments. And that the current system protects judicial independence, and that there would be an increase in politicization if each president got to appoint 2 members. Again, I think this was a solid minority on the commission, but we don't know how they voted, or I don't know. Then what do you do if the President Biden gets to have 2 appointments and he appoints a judge, and the Senate has switched next month, and Mitch McConnell says, I'm not going to appoint, we're not going to confirm anybody that Biden appoints. So what do you do? And so the commission talked about this. One approach would be, you say, if the president gets to make an appointment, and if the Senate doesn't reject it within, say, 3 months by a 2/3 vote, that person's on the court. A number of countries have that. Another approach would be, if the Senate doesn't act within a certain period of time, then all the chief justices of the 9, 10, 11, 12 circuit courts of appeals, there's the DC circuit too, they all get together and they vote in a justice. So something you got to worry about. The last big topic on this 18-year proposal is this going to take a constitutional amendment or not? This is the big question. And Bill alluded to this. The provision in the Constitution, Article 3, Section 1, says, the judicial power of the United States shall be vested in one Supreme Court, and such inferior courts as Congress may from time to time establish. That sentence doesn't tell you who's on the Supreme Court, how long they're on the court. And then it says the judges, both of the Supreme Court and the inferior courts, courts of appeals, district courts, hold their offices during good behavior and shall basically not have their compensation reduced. But there's nothing here that tells you that Congress can't rotate judges up and down from the Supreme Court to the courts of appeals or vice versa. And one of the concepts is, look, we need to have a junior and senior judge system. So all the new judges, the ones that are appointed for 18-year terms, they're junior judges, but they're really senior. I mean, they're making the decisions. And the seniors they either retire or they can go to work on the Court of Appeals like David Souter, who enjoys it. Or another approach is the senior judges, after 18 years, they get to sit on the boring cases like squabbles, original jurisdiction cases, squabbles between the states over shifts in river boundaries. Then there are a few other original jurisdiction items. They're fascinating, but you wouldn't want to do it for 18 years. And proponents point out that there's a long history, we saw this in an earlier slide, of adjustments in the jurisdiction of the courts, federal courts. They're actually a pretty narrow jurisdiction. What the courts can and can't do, whether there's a courts of appeals, whether the members of the U.S. Supreme Court have to ride their horses on circuit around to hear cases. Congress has always made a bunch of the rules governing the Supreme Court, and it was, 80 years before they quit having to ride horses around to hear things around the country. And then the arguments against a statute being able to change the system is that it would violate the life, tenure, and good behavior clause, and that the Constitution doesn't allow changes in justices' duties. It doesn't prohibit it either. And a senior justice would be deprived of office. The office is being on the Supreme Court, as opposed to being a junior or senior Supreme Court justice. But, this is the argument. So the arguments are out there. It would take a pretty big shift in Congress, I think, to get a statute through on this. On the other hand, a constitutional amendment takes a supermajority of each house and then 3/4 of the states, and that is a heavy, heavy lift. So the other thing I just wanted to mention, that was in the commission's report, and I think this was at the behest of their traditionally conservative academic members, is one proposal was that the Supreme Court should be stripped of judicial review jurisdiction entirely. Congress might be able to do this, but I'm not sure John Marshall would agree. Who knows? Another proposal, and this would really take, I think, take an amendment to pull this off, but who knows? You would take a supermajority requirement to nullify legislation, and do some other things to increase judicial deference to legislators, or permit congressional overrides of rulings that nullify acts of Congress. This is not unknown. In the Netherlands, a supermajority vote of Parliament can override the Constitutional Court. In Canada, any province, parentheses, read Quebec, parentheses, any province can nullify certain kinds of rights decisions. This is to protect their language rights, that are rights decisions of, under the Charter of Rights by the Supreme Court of Canada for, I think, 5-year periods for a couple of times, so they can basically slow things down. In Ireland, in its constitution, there's a provision that says that its Supreme Court cannot nullify legislation at all, because it's a parliamentary democracy. You don't want the judges doing that. So, you know, there are other countries, including democratic countries, that don't have judicial review of legislation like we've had since since Marshall and Marbury versus Madison. And there was debate about it back then, and there is today, but that's not going anywhere. So I'm going to just stop right there, maybe take a few questions for 10 minutes or whatever, and both of us can answer questions.
You're going to ask the questions?
So,
Just don't give me the hard ones.
so, I'm gonna take a question, but you're gonna turn your microphone off for
Right.
mine to work.
Okay.
And then once they're done answering questions, you can turn yours on to
It's
answer.
on. It's off.
Okay. Questions? Really?
This brings it to the very present, which is the situation with Clarence Thomas. Could you comment on it, please, even though it's not on the agenda?
Oh, yeah, the question has to do with Clarence Thomas and issuing all by himself some kind of ruling today, saying that the grand jury in Georgia can't, for a few days anyway, can't call upon the can't haul in the senator from South Carolina. Okay, now. Lindsey Graham. Clarence Thomas has a real blind spot when it comes to certain ethical issues. I think that it drives Chief Justice Roberts crazy, because he's an institutionalist. He really cares about respect for the court, and he can't control Clarence Thomas, and he can't control Alito. And it's pretty sad, but what can you say? He's there, and he's going to be there for life, unless something changes.
There's a saying that there's no such thing as a dumb question, but this is close. Are there always odd numbers?
Are there always odd numbers on constitutional courts and our Supreme Court?
Courts.
No. We've had 6. We had, let's get that little chart. They weren't so worried about it. Yeah, we've had 6, 10, and a number of courts around the world have even numbers. On appellate courts or constitutional courts, you don't need to have numbers. It's just that you still probably have to have a majority for a decision. but there's nothing intrinsically requiring an odd number, no. And not a dumb question.
Very interesting. You mentioned that getting any of these reforms passed by statute is unlikely, I suppose, given the current nature of Congress. But if both houses were controlled by one party, what would you need to get a statute passed?
Yeah, to get a statute passed, it requires a majority vote of each house plus signature of the president upon presentment of the legislation. So right now, unlikely, given the state of the Republican Party, the Republican-controlled Congress would do this. But remember, a shoe can always be on the other foot, and that's why I say that intellectually honest conservatives, think that this is a good idea, whether or not it can be done by statute. But yeah, it just takes a majority. And these days it means a Democratic majority, but these things change. Bill, jump in.
I will.
Is there any way that Justice Roberts can force Clarence Thomas to recuse himself if any case comes before the court involving his wife or any of her issues?
Yeah, so Congress, the question has to do with, can you force a member of the Supreme Court to recuse himself or herself? No, there is a statute on judicial ethics, federal ethics. It covers the federal district courts. It covers the courts of appeals. It does not cover the U.S. Supreme Court. And there's nothing that Roberts can do other than go into his office and yell at him, right? And you didn't get anywhere with Clarence Thomas yelling at him.
Stu, would you care to predict if, when, how any changes might be made?
Yeah, I'm not a betting person, but like I just said before, it requires a solid shift in the membership of Congress and then having a president who wants to see these changes. It takes a supermajority vote to get an amendment out, but I could see a legislative adjustment. Now, remember, if Congress were to pass legislation moving to an 18-year term system, and it were challenged as being unconstitutional, who's going to decide that case? It's the U.S. Supreme Court. And if they don't like it, who knows what they're going to do. But, oh well. Maybe one more question? Going once?
I have a question, Hugh, and it's not on the topic of the Supreme Court. You've been teaching for many years out there now. Could you tell us a little bit about the students who are coming through, the younger people who are aspiring to careers in the law and possibly the judiciary?
Yeah, students today. It's really interesting. They're real smart. They seem to get smarter every year. They get younger every year too. No, they're really bright, pretty diverse, diverse racially, diverse in terms of backgrounds. Really interested in law, and because of their devices, they have lost, many of them, the ability to read. And I started seeing this 15 years ago for my state constitutional law class. Heavy reading. First, they were saying it's just the reading's too heavy. So, okay. So I started cutting back. And they said, the reading's too heavy. So it went from 3 to 4 credit hours. And they still have a tough time. They don't read like we do. They everything's in these little short glumps. And so you have to teach somewhat differently. People use a lot more, professors use a lot more slides and a lot more sort of takeaway things. They're just as bright as ever. They're going to be great lawyers, but they do have a tough time reading. And ultimately, to be a lawyer, you actually have to sit down and read the gosh darn cases. So I don't know what the solution is. Oh, I'll tell you why. One of the problems is the cases are longer. Back when Oliver Wendell Holmes was writing cases, he told his clerks, you can't, I'm not going to have any opinion that's more than, I think it was 4 written pages, printed. Why? Well, for one thing, he had to write his opinions by hand. I remember writing briefs by hand. Well, that really keeps them short, huh? And now they got these gosh darn machines, so you can write these 200-page opinions. Who the heck can read them? It's stupid. Okay.
I think it was Oliver Wendell Holmes who wrote those short opinions. And his phrase was, "The sagging in the knees conduces to brevity."
More questions?
Bill? One more. Yeah. Last question.
I'm coming.
Reese's coming, thank you. Some of the appointees have surprised the presidents that they were appointed by on how their opinions turned. I think Warren's probably the biggest surprise of all of them. Do we expect any of the people that are in the court these days to surprise their presidential or anyone that appointed them?
You know, watch Kavanaugh. You know, never mind all the trouble that he got into in college and beforehand. Maybe Amy Coney Barrett will get a part in 20 years. I mean, Sandra Day O'Connor was a solid conservative. William Rehnquist, when they were in law school, asked her to marry him. She said no, but they became, friends for life. She was just a perfect Reagan appointee, and wow, did she change? I don't know, but besides Kavanaugh, maybe Kavanaugh, I don't know. Roberts, maybe.
Roberts is the one who impresses me most in that group, because he is, as you say, an institutionalist. He really cares about professionalism in judging, and he's very concerned about the reputation of the court, and more deeply the legitimacy of the court. Courts have if they don't have legitimacy in our minds, they're meaningless, and so it's terribly important to protect that, and he's very serious. But whether he's going to change much, I don't know. You may know in the Dobbs case, he filed an opinion which went along with the majority, but didn't like the majority's opinion. He thought you could reach that same result without overruling Roe against Wade, which had left us in a much more flexible situation than we're in now. So he didn't vote against the majority, he went with them, but he had an entirely different theory. And that theory, I think, is much more intelligible as a professionalist in the judging world. And we used to have a friend, a young woman from France, and we asked her when she got out of legal training, what kind of profession she wanted. She said, "I want to be a judge." And I said, "Well, what does that mean in France?" "Well, in France, it means you decide right then. That's your lifetime job. You're going to be a judge. And you start off in judges school, and after you get out of that, you're appointed to some, I think she was off in
municipal court in Normandy.
Yeah. No, it was further than that. It was out in the South Pacific someplace. But gradually, being evaluated by the senior judges in her system, she gradually works up, and sooner or later she gets to be in France at the higher levels, and when she gets to the very higher levels, she will be in a part of the French judiciary which is regarded around the world as the best. In America, judges are amateurs. They never judged before. They just walk up and say, "I'd like to be a judge," and file my name for this election, and they get to be judges. They learn on the job. Now, some of them are very good, and some of them learn a lot in a hurry. but it's strictly a job for amateurs who are politically connected. And that's not the system in a lot of other countries. And I'd like to see more of that.
Yeah, I will say in France, the judges are often viewed as bureaucrats because they are civil servants. They're in the system for life. But as good French civil servants, they go on strike. And I've got one slide, but I didn't bring it today, of these judges in beautiful crimson robes and ermine trim, carrying signs on strike outside the Palais de Justice. All right.
Other questions? Let me just say one final thank you to Hugh. Thank you all.